All right, everyone, welcome. Welcome back to class. Hopefully everyone enjoyed some pizza, but save the beer for later. We got some people absent. No people are on their way. Okay, all right, we'll start. They'll get here when they get here. All right, so my goal for today is to, our goal for today is to focus on the interaction between the president and the Congress. And specifically, where they do not get along. So we've talked about cases in the past like Youngstown. This was a steel seizure case. And in Youngstown, the president took the steel mills and Congress was silent, right? Didn't say a word. We've done other cases, and I'm sure you study them. For example, the line item veto case, you might recall, where Congress passed this line item veto. Okay, Congress agreed with it. All different branches of government agreed. Our goal for today is to talk about what happens when the president and Congress can't get along. And this is hardly an academic question. If you open up any newspaper, go to any website, or turn on any radio station, you'll hear this word over and over and over again, gridlock. That's the only word we hear. There are studies saying this was the least productive Congress ever that's only passed the fewest number of laws in 100 years, whatever the number is. And what I hope to convey to you today is that gridlock need not be considered a bad thing. In many respects, gridlock is a symptom of underlying problems, right? Gridlock is not the sickness itself, but it's a symptom of an American populace that doesn't agree. And when the American populace doesn't agree on things, it's not surprising that Washington comes to a halt. Because our Constitution was designed to require a lot of people to agree on anything before stuff gets done. And if people don't agree, the different points don't line up in the process, things kind of stand still. And they maintain the status quo. All right, so I'm actually going to walk you through, this is one of the presentations I give. I do a lot of speeches nationwide, different law schools. This is one of the shticks I give. So I'll give you part of it today, but I will break into discussion. I usually don't like PowerPoint, and this will have no words, and I promise you all photos. But I'll give you a little bit of the shtick I give. 144 slides, no pictures, no words. The entire thing's only pictures. It's really telling a story with pictures. If any of you want to do this, I challenge you. For your presentation, if you want to do a PowerPoint, I amend my thing. No words, only pictures. You can do it. If you can pull it off, it's not easy. But if you're using only pictures to demonstrate, I'm not talking about like stupid clip art and flying animations, right? Photographs that have symbolism and that mean something. These things take me about 48 hours to make for one presentation. That's why I don't do it for class. It's too time consuming. But it takes me 2 full days of just downloading pictures and sorting and putting them in the right order to actually convey a narrative. But it can be done. So I challenge you. If you want, I think Hugo, you asked, if you want to do a PowerPoint, only pictures, no words, not even bullets. Anyway, so Washington, D.C. always has this perception of being gridlock. You have this traffic where you have the two parties are butting heads against each other. And effectively, there's a wall built down the center of Congress. But in many respects, I think as we'll see in the Noel Canning case, this gridlock is a symptom. Right? It's a reflection of what's going on underneath. So let's talk about the National Labor Relations Board, which many of you have ever heard of. Has anyone ever taken a labor law class or an employment discrimination class? You probably should, because no matter where you worked, no matter what office you work in, people will be making allegations of labor. Employment discrimination, fair wages, doesn't matter. Any company where you work has employees. Have their employees, there'll be labor issues. I promise you. So if you can, take a class on labor law. It's very interesting stuff. So the National Labor Relations Board sets policy about how to manage unions, how to manage contracts, how to manage fair labor relations, and things like that. And this board has 5 members, right, through these 5 independent commissioners. And the president can appoint these commissioners for 5-year terms. These aren't like Article 3 judges where, you know, they're in office for life. These are 5-year terms. And generally speaking, once these 5-year terms, the president appoints someone else. But if for whatever reason there are only 2 members, in other words, if they drop below 3 members for the quorum, they can't decide anything. Okay? Under the rules of the National Labor Relations Act, you need at least 3 members on the board. So what happens if there are 3 people and one of their chairs expires and the president doesn't fill it? The board lacks a quorum. What happens when the board lacks a quorum? They can't transact any business. Not only that, what happens, and this actually happened during the Bush administration, where the Democrats in the Senate blocked all nominations to the National Labor Relations Board. This is not new. This happened already. So during the Bush years, the Democrats in the Senate blocked any nominations to the NLRB. They blocked them. They said, close it down, shut it down. We don't want all these conservative people making bad labor policy. As a result of the Democrat filibusters, then there were 2. There were only 2 members of the National Labor Relations Board left. Can these 2 people, look how lonely they look, in the hallway. I love this picture, right? See what I'm saying? Pictures to tell stories, right? Can these 2 people by themselves make labor policy? Well, they did it anyway, even though they weren't supposed to, and the Supreme Court said, no, you can't do this. Okay, so their decisions were vacated. But this problem emerged again in 2008 and then 2010 when President Obama was in office. So the same way that Democrats were blocking Republican nominations to the board, now Republicans were blocking Democrat nominations. There's nothing new under the sun. So whatever's going on now happened during the Bush years. So President Obama nominated this guy. His name is Craig Becker to be a commissioner in the National Labor Relations Board. He was a union lawyer. And his nomination occasioned a serious political fight. It's a political fight they're fighting. Specifically, this guy was a former lawyer of the SEIU, which is a huge labor organization. So basically, Obama's letting the wolf into the henhouse, so to speak. We're putting a union lawyer on the union board. So the Republicans opposed this and said you have to block him. And his nomination was blocked. Of course, you need the advice and consent of the Senate. And even though the Democrats had a majority, at the time, you effectively needed 60 votes, right? And the Republicans filibustered. They blocked Becker's nomination. So what happened? The board was going to drop below 3 members. There was only going to be 2 people left. And again, once they have 2 people, they can't transact any business. They can't do anything because they lose their quorum. So what did they do? The president looked to his recess powers, right? And I want to show you, I love this quote. This is a Mark Twain quote. I hope it's real. No man's life, liberty, or property are safe while the legislature is in session. Well, as it turns out, even when they're not in session, our liberty is hardly safe, as we shall see in this case. And this brings us to the recess appointment clause, which you have in your constitutions. And if you want to open up, it's on page, someone has it called out, page 30, right at the bottom. Last paragraph on page 30, okay? It says, and if you don't have your constitution, it's up there, the president shall have power to fill up all vacancies that may happen during the recess of the Senate, okay? What do these words mean? We'll come back to that in a bit. But generally speaking, we know that when there's a recess, the president can fill any vacancies that happen during the recess, whatever that means. All right, so let's go back to our show. So here's what happened, okay? I don't know what just happened. Oh, I know what happened. So during the Senate, there we go, okay? During the month of December of 2011, the Senate said, you know what? We don't want to be here all Christmas time. We want to go home to our families. So here's what we're going to do. Every 3 days, a member of the Senate, usually from Maryland or Virginia, it's always one of those locals, comes in and holds a pro forma session, right? What is a pro forma session? Well, I can show you what a pro forma session is. A pro forma session is a short session where the Senate gavels in and gavels out. Here, watch the entire thing. This didn't work in my earlier class. See if it works here. Nope, not gonna work. Let's see, try this, ready? This is why I never do video during presentations. It never works, ever. Anyway, so effectively what happens is the senator comes in, he gavels in, says a few words, and then gavels out. The entire session lasts barely 20 seconds. Okay? The entire session lasts barely 20 seconds.
There's no script that he has to put on.
There is. Let me see if this video works. I'll play a few. Here it is. I'll show Eddie. I'll show you the entire thing. It'll take. Your question took longer than the actual session. I'm not exaggerating. Okay. Pay attention, or else you'll miss it. Ready? Here it comes. Here, ready?
The Senate will come to order. Pursuant to the Constitution, the hour of 12 noon, January 3rd, having arrived, the Senate convenes the second session of the 112th Congress. The clerk will read a communication to the Senate.
Washington, D.C., January 3rd, 2012. To the Senate. Under provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable Mark R. Warner, a senator from the Commonwealth of Virginia, to perform the duties of the chair. Signed, Daniel K. Inouye, President Pro Tempore.
Under the previous order, the Senate now stands adjourned until 11 a.m.
That's it. That's it. You didn't actually hear the gavel off, whatever C-SPAN cut it off, even they got bored, right? When C-SPAN's bored, you know you're in trouble. Yeah.
And so the only ones that they actually described in that case were the inter.
Oh, I'm not there yet.
Right, but this is a third one. This is different than those two, right?
I'll get there in a few minutes, okay? I'll get there in a few minutes, okay? So what happened was every 3 days during the month of December and January, where everyone was home for Christmas, the Senate held these pro forma sessions, right? So if you turn to your Constitution, the 20th Amendment, right? I'm sure you all read the 20th Amendment many times, right? Might be your only time you ever have to read it. It's on page 52, right? Section 2 of the 20th Amendment says, the Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January. If you heard what he said it very quickly. It's like, this being the 3rd day of January, according to the Constitution, the Senate is now in session, gavel. They read some speech that had no significance. It's like, that being all, gavel. Done. So they had on January 3rd, the start of the new Congress, right? The presidential, the election just happened. Okay? I'm sorry, they started a new session of Congress in 2012. Okay? What ends up happening is on January 3rd, they have this recess appointment, this pro forma. There's another one scheduled on January 6th, so basically every Tuesday and Friday.
Also conducted by the senator from Virginia?
Always.
Or Maryland?
Either Virginia or Maryland. It's always one of the two, right? Oh, it's usually whoever the local is, right? So you have this 72-hour gap, okay? What happens during the 72-hour gap? President Obama says, you know what? I decide that the Senate is in recess. It's my decision the Senate is now in recess. He actually had a memo from his Office of Legal Counsel, which is somewhat laughable, but he has a memo that says, I can appoint these 3 people to the National Labor Relations Board. And he makes them on January 4th, during this 3-day break. And once again, the board has 5 members. Okay? We'll get to the details of the intercession in a few minutes. But so what happened? Okay, so now the board says, hey, look at us. We have 5 members. We're so cool, right? Let's actually become an agency and do some work. So there's a company called Noel Canning. They're a Pepsi bottler in Yakima, Washington. And that's an unfair labor issue. It doesn't even matter what it is. The Supreme Court gave it an entire paragraph, the facts of the case. They're not very important, if you noticed. And the National Labor Relations Board issued a judgment against them, saying, you need to do so-and-so. So what did Noel Canning say? Hey, wait a minute. You can't tell me what to do. You guys don't have a quorum. You might have 5 people in those chairs, but 3 of you were appointed unconstitutionally. And because you were appointed unconstitutionally, you lacked a quorum, you can't tell us what to do. So they go to court. They go to the DC Circuit Court of Appeals. They say, DC Circuit, get rid of this order. You can't tell us what to do. And the DC Circuit agrees. So the case gets appealed to the Supreme Court. And the president's appointments are at issue before the justices. Okay? And now I'll pause and I'll come back to my in-depth discussion. So everyone get the facts of the case. The facts of the case are really interesting of how this went about. So we have here the text of the Constitution, right? And there are 3 parts I want to focus on. I highlighted them in different colors, so you really know what I'm talking about. May happen, recess, and recess of the Senate. Okay? These are the 3 questions presented by Justice Breyer in his decision. Right? The first question Breyer asks is, what is a recess? Okay? What is a recess? The second question Justice Breyer asks is, what does it mean for vacancies may happen? Are these vacancies that arose during the recess or before the recess? And the third question that Justice Breyer asks is, how long must a recess be for a president to make an appointment? Can Congress go out for a lunch break and the president makes an appointment while Congress is at lunch? They're at lunch more than that. But can that happen? So it's very interesting, the actual textualist, historical, and originalist type arguments, right? What makes this more interesting, though, what I want to focus on here, is the relationship between Congress and the executive with respect to acquiescence. And this is a point we've discussed a lot in this class. So let's see. All right, we'll just start at that. So what does Justice Breyer from the majority think about this? He effectively says that for at least the last 75 years, right, presidents have been making appointments during both intersession, meaning between the breaks, and the intrasession, meaning within the session, right? So for a long time, at least 75 years, maybe even longer, presidents are making both these appointments. What's Justice Breyer's argument? How do we understand that level of acquiescence? What does that mean?
He said that there are no relevant opposition from Congress. Occasionally 1 or 2, but very minor, doesn't count. Right.
So what Justice Breyer says, if any of you have ever seen that Allen Iverson video about practice, I'll be using the word way too much today. It's practice, we're talking about practice, right? So what happens to Justice Breyer is he's very big on seeing what has Congress actually done. Which is interesting, because in other contexts, the Supreme Court said, is that when you're dealing with a separation of powers, it doesn't really matter what the parties agree to, right? Casey, why does it not matter whether the parties, whether Congress and the president agree that this is a proper allocation of power? Why should that not matter?
Because you should just look at the Constitution. It's probably pretty often that they don't agree.
What do you think Congress, we did this in the very first class, how do you think Congress and the president usually feel about power? What do they usually? They both want it. And how do we, in our Constitution, how do we prevent that power from being exploited from one hand to the other?
Separated.
What's that word?
Separation of powers.
Check.
Check. Checks and balances.
Exactly. And we discussed in the very first class, Madison, Federalist 51, said, ambition must be made to counteract ambition, right? When you have an ambitious president and you have an ambitious Congress, they check each other. What happens when you have an ambitious president And Congress doesn't really give a damn. Congress like, yeah, whatever, we don't care. Gwen, what happens then?
They don't really care.
Yeah, the president is saying, oh man, I'm going to take all this power for myself. And Congress is like, well, whatever, go ahead, do it. Is ambition checking ambition there? What's happening then?
The president has, it seems like the president has more say whenever Congress doesn't act.
Yes. So Angelina, in any, and this is Justice Scalia's point, any long-standing conflict between the executive and the Congress, right, between the president and Congress over power, who wins that battle? Any long-standing fight between the president and executive, who's going to win that battle?
What does Scalia say?
Well, what does Scalia say? Yeah.
I'm not sure what he said.
Well, what do you think?
And that kind of tripped me up a little bit reading Scalia. I didn't really get how that was.
So what do you think? In any long-standing battle between the executive and the Congress, who do you think will be more powerful of amassing power?
I think ultimately Congress, although I think maybe at times presidents.
Well, which one is it?
I would say Congress.
Why do you say Congress?
More people, more representatives.
Well, when you have more people, is it easier to pursue a single path?
No.
Why not?
They're going to have different thoughts, different ideas, different theories, different reasons. And arguments.
Exactly. So this is Scalia's insight, right? Scalia says in any battle between Congress and the president, in the long term, the president's going to win every single time. Why? There's one president and 500 members of Congress. It's like herding sheep, right? Trying to get everyone in Congress to agree to a single goal and accomplish certain things, not going to happen, right? And then Alessi, I'll ask you a follow-up. What happens when half of Congress is of the same political party as the president? Do you think they're going to care if their president's violating the Constitution? Why not?
Because he's on the same path as they are, same time frame.
So in many respects, ambition fails there because the ambition of Congress matches the ambition of the president. And we can look to contemporary debates about immigration or Obamacare or whatever else you will, where effectively where half of Congress or roughly half of Congress agrees with the president, they're not going to check anything. So in any long-term struggle between the executive branch and Congress, the president's going to win. And this has been effectively the story of the last century. It started during the New Deal, which I'm sure you studied, and went through the present day, where Congress began delegating so much of its power. And they didn't just delegate the legislative power. Scalia argues here, they actually delegated their check on appointments. The Constitution gives the Senate the power to check who the president appoints. By acquiescing to these intra-session recess appointments, Congress has basically given away their power. Because it used to be, originally, if you ask George Washington, John Adams, or Thomas Jefferson perhaps, the only appointments the president could make were with the advice and consent of the Senate. The only exceptions to that were appointments between sessions. So imagine you're in the summer of 1791, it's really hot in Washington and in Philadelphia, right? So in June, everyone goes home. It's like, all right, boys, we'll be back in January. Take the summer off. There's a 5-month recess between sessions of Congress. It makes a lot of sense for George Washington to have to appoint someone during that 5-month break because Congress isn't there. Lauren, is that the issue today where the recess power is being used to deal with some sort of a congressional absence? Is that how it's being used by the president? How's it being used?
He's using it to probably to fill in who he wants to be, like to more people that are either in his party or that are supporter.
Well, what's happening before? Is the Senate confirming his people?
No.
Think of Craig Becker, right? The guy, the union lawyer. Did they approve his nomination?
No.
So how is the president treating the recess power? Is it a way to deal with congressional absence?
No, it's more of a way of kind of like a well,
Is a problem that the Senate's not in town? They can't fly home in time to make an appointment. That's the problem.
No.
What's the problem here for the president?
the problem is the problem is that he's just making a decision that affects them without them being.
Why is the president having to do this in his mind? What do you think? If you ask President Obama, why do you have to do this? What's your justification for this, Kelsey?
Well, he has both the House and the Senate against him, like he doesn't have his party in the dominant, either the House or Senate, so he's taking it basically into his hands in order to pass the legislation.
Very good. And this is actually one of the key insights of Noel Canning that only came out incidentally in the opinion. But it came out during the oral argument. So if you ever want to have, if you have like an hour that you want to kill, listen to the oral arguments in this case. It was argued by Paul Clement, who's one of the top, actually, Noel Francisco is the top lawyer in Washington, and the Solicitor General. I actually have some of the excerpts from here. I don't have the audio. Again, audio never works, right? Media never works well, so I don't actually like PowerPoint because it always breaks. But by the way, I love these pictures of Breyer and Scalia. A couple years ago, they actually testified in Congress on behalf of the Constitution. It was hilarious. And this one, he was like, no. And here it's like, look at this guy's crazy. What's he doing? They're very entertaining. They don't get along well jurisprudentially, but in personal terms, they get along very well. They have very good sense of humor because Breyer has this very dry sense of humor, and Scalia is so gregarious. They actually get along quite a good rapport. But I want to focus on one aspect. So during the oral arguments, Justice Kagan, I'm a Kagan fan. Justice Kagan goes to the Solicitor General, and this is her quote. And again, she says, these recess appointments, right? You're not trying to deal with congressional absence. This isn't the case where, it's 1791 and someone needs to ride their horse and buggy from South Carolina to get home in time to fill an appointment, right? Every single member of the U.S. Senate can be in Washington in 24 hours, wherever they are. If there was actually an emergency, you're in the middle of a war and the Secretary of Defense is killed in battle, a really serious emergency. Within 24 hours, you can get everyone in the United States Senate to come to Washington and confirm someone else. There's no question about this. So Kagan says, listen, you're not trying to deal with congressional absence. You're trying to deal with congressional intransigence, right? What is this congressional intransigence? Yeah, what's this congressional intransigence? What does that mean, congressional intransigence?
It means that they're not going along with what the president wants to do.
They do not agree. Yeah. That's right. Congressional intransigence basically means they don't agree. They do not agree. So Kagan's saying, listen, the reason why you made these recess appointments wasn't because the Senate was out of town, right? They were within a day's notice. And if it was actually an emergency, they could have been hauled in a day's notice. In fact, the president's had power to convene Congress. He can call an emergency session of the Congress, bring them in, make them vote. But what was happening here was Senate voted. They voted no for his guy. They voted his guy down. So what's really interesting.
It's kind of an originalist argument to make on her part.
Well, I think it's a very good argument to make. I mean, Kagan effectively said what Scalia said in his opinion. She said the recess appointment power is something of anachronism, right? It doesn't have any meaning anymore because if everyone has an airplane and they can be brought into Washington, D.C. on a few hours notice, you don't really need this power. Go get the Senate's consent. But the response from the government lawyer, Donald Verrilli, who's a Solicitor General, we will talk about him a lot when we discuss Obamacare. His answer was fascinating, and this was not ad lib. They don't make stuff up when you're the top government lawyer. This is rehearsed. This was in the briefs, but it was definitely rehearsed. And he goes, well, Justice Kagan, the recess power acts as a safety valve, given that intransigence. The president's ability to make the recess appointment without the advice and consent of the Senate is a safety valve. Now, what do you mean safety valve? I mean, if you know, safety valves are often on these little steam things, right? Think of a teapot. I'm a little teapot, right? When it gets all steamed up, right? It is a teapot dome scandal if you're history buffs. But when it gets all steamed up, you have to tip it over and pour it out. So it really was basically arguing, and I'm positive because Verrilli is a very smart lawyer. This was the government's position. What Verrilli is basically arguing is that when the Senate gets all jammed up, pressure, like all the steam, this release, right? There's a release to allow the Senate, allow the president to get his people through. I mean, Brandon, what do you think the president through the attorney general meant by a safety valve? How do you think he envisions his executive power?
If he's not getting what he wants, he can just call a recess and make his vote down.
That's pretty close, yeah. So, I mean, it's a little bit more nuanced than that. But what the government's arguing here is that when Congress doesn't agree, when Congress is deadlocked, this actually justifies the president using these forms of executive action to accomplish things which he could not otherwise do. Because think about it, if the Senate voted all of his people in, he would never need to let out the steam. But when there is the steam, that justifies the executive acting in this fashion. Everyone see that? Questions on that? This was a point of argument that a lot of people missed, but I think was very important. Because what happened is all 9 justices jumped, oh, Thomas doesn't talk in arguments, but all the justices there jumped all over him, okay? Justice Alito goes, whoa, that is a very aggressive argument in favor of executive power. All right, this is not how Congress works. So a little background for this one, right? Barack Obama holds a distinction as the only sitting president to ever vote against the justices of the Supreme Court. As a senator, he filibustered John Roberts and Sam Alito. He voted against both of them. Okay? So John Roberts, perhaps with a sense of irony because he's very witty, says the Senate has an absolute right not to confirm anyone. And the irony there is Obama voted against him. So effectively what the chief is saying is, listen, Mr. President, right? They don't have to vote for Craig Becker. They're not required to vote for your guy for the NLRB. They don't have to vote for anyone. More broadly, Ian, is the Senate required to pass any bills to the president? No. Of course not. This meme, which we hear far too over, is pass a bill, pass a bill. They're not required to. There's no obligation of Congress to pass laws. Now, maybe they should or shouldn't, but there's no obligation to. And if they fail to pass a bill, or Ian, if they fail to vote for Craig Becker, what can the president do? What happens if Congress doesn't vote for Craig Becker? What can the president do?
I guess he could wait till then.
Give me the constitutional answer. What could the president do if the Senate votes down his nominee? Really easy. Oh, he could do nothing. What else could he do? Zach, what do you think?
Just get the next nominee on the list.
Yes! Appoint someone else. And maybe the replacement will be a little bit more moderate. See, it's remarkable that in this day and age, the idea of appointing someone else didn't come to you naturally. And it's not your fault, right? The essence of compromise is if you nominate someone who the other party doesn't like, maybe nominate someone else. Is that such a radical idea? I mean, but instead, the president feels justified and compelled to make these odd constitutional, quasi-constitutional moves. So the Chief Justice is saying, listen, whether or not Craig Becker gets appointed, right? Now, Eddie, should it matter at all that if Craig Becker didn't get nominated, the board will lack 3 members, they lose a quorum, they shut down. Should that matter at all?
Sure.
Okay, in what sense?
It's immobilizing significant decisions that need to be made in the interest of labor, et cetera, et cetera.
Okay, so there was definitely a problem. Now, does that problem, Eddie, justify the president sidestepping the Constitution? Okay. So what the president basically argued, and I didn't put this up there, But the government said, listen, if we didn't do this, the agency would go dark. That's the phrase, it would go dark. It would shut down. And they said, listen, we have a national, this is a crisis, right? Okay, so the idea that this is a crisis is really hard to square. First of all, they knew this was coming months in advance, right? This isn't like the Secretary of Defense who was killed in battle, right? They knew this was coming months in advance. There were votes for this guy. I showed you, there were commercials on TV opposing this guy. So the president could have, if this was such an urgent thing, put someone else on the board. Okay?
And the nomination was actually delayed in the first place. He didn't nominate him as soon as he could have. He delayed it purposely because he knew he was going to bring someone controversial. And he wanted a small time frame with which to.
Oh, I'll give you one better. So I'm sure while this case was being argued and while you're reading, say, well, the Republicans wouldn't confirm any of his nominees, right? It's like, oh man, the Republicans wouldn't confirm anyone, right? Wrong. While this case was pending on appeal, what happened? The Senate and the president reached a deal where they confirmed 3 people to the board who were much more moderate than Becker. So the very crisis which was, relied on here didn't actually exist. They eventually reached a deal and they put 3 people onto the board. As another so-called footnote, those 3 appointees were a deal in order to avoid the nuclear option. Okay, so what's the nuclear option? Anyone know what that is? So in the last decade or so, every single appointment, every executive branch appointment was subject to a filibuster, all of them. You needed basically 60 votes to get anyone onto any agency. The nuclear option says no. The Constitution only says you need 50. So they would change the rules in the Senate to only put 50. So one of the deals the Republicans struck with the Democrats was, we'll confirm these 3 people if you keep the nuclear option in place, if you keep the filibuster in place. What happened a year later? They got rid of the filibuster. They did the nuclear option. So the very deal that staffed this board was basically ignored a few months later. Hardball, serious hardball. In fact, when the Republicans took the Senate I guess now a month ago, they considered bringing the filibuster back, but they, in my mind, wisely decided to not have it. There's still a filibuster for the Supreme Court, but every judge in the Court of Appeals, every director of whatever, there's no filibuster anymore. Eddie, has your hand up?
Are you saying that they filled the positions on the National Labor Relations Board, those 3 positions, they filled those?
Yes.
While this case
Was pending.
Then I'm going to ask, probably it's going to be a very dumb question.
It's not.
Wasn't it moot?
No. Because the decision against the Noel Cannon company was issued by the fake board members. Right? The decision issued against the Noel Cannon company was by the 3 fake members who never appointed. Now, what ends up happening is they vacate the order from those fake judges, the fake members, and it gets reissued by the new ones. So there will be no Cannon still loses, but the actual order was still alive. This did come up in the case though, because some suggested the case was moot. Right? So this is this issue of gridlock, right? And I want to focus on this rapport between Scalia and Breyer. And on this point, all the justices agree. They all 9 agree. Right? Breyer worked for a number of years in the U.S. Senate for Senator Ted Kennedy. He was the Senate staffer, so he knows Congress. He knows Congress probably better than anyone else in the court. And he says, listen, gridlock, people don't agree, right? This is a political problem, not a constitutional one. The president has certain tools at his disposal to get around this gridlock. One of the most famous is Teddy Roosevelt, who spoke of his bully pulpit, who used the power of the presidency, the office itself, to put weight on people and to twist arms and to cajole people and persuade people, right? But when that doesn't happen here, there's a serious problem, right? Because the president is doing it alone, right? Rather than using the powers of persuasion, the president acts alone. Okay? So that brings us to some of the other things. So I asked you to read an article I wrote, at least the short version of the article I wrote, which discusses some of the big issues. And the rest of this class will be somewhat of a summary, which you may or may not be familiar with these topics. But there are many areas in the law today where gridlock is cited as a reason why the president can act unilaterally. And the president's been very clear about this. And he's said that, you know what, if Congress doesn't give me what I want, I have my pen and I have my phone. Right? What does that mean, I have my pen and my phone? Well, I can sign an executive order and call and tell people what to do. And he's been very candid about this for the last couple of years. And we'll discuss this more in a few weeks with respect to immigration. But the philosophy that has emerged, right, has been one of confrontation. And it's not unjustifiable, right? Congress isn't voting for whatever laws the president wants. He's blocking stuff. So the president says, listen, when we have a serious problem and Congress chooses to do nothing, right, I will take executive action. And I think Noel Canning, it can be viewed as an example of this, right? There's a problem. The members of the National Labor Relations Boards are about to expire. The board's going to drop down to 2 seats. They're going to lose their quorum. And as Eddie correctly said, labor policy stops. No more labor policy in this country. Unfair labor practices, no one's going to enforce it. Okay? So I think we would all agree that indeed there are some serious problems in our society. But I would push back against this characterization of Congress choosing to do nothing. Congress is doing something. They're voting against a policy. When the Congress votes down a nominee, they're doing something. When the Congress votes against an immigration law, they're doing something. It may not be what the president likes, but they're absolutely acting. This is not inaction, right? I love this one. So it's often joked that Congress just stopped the first 5 words of the First Amendment. Congress shall make no law, period. There are t-shirts with this on this. Anyway. So gridlock, though, I think can actually be viewed as a product, as a symptom of the fact that Congress doesn't agree. I'll go back to a second. So did I tell you this study about the partyism? Did I tell you this study? So this is fascinating. So there are general surveys done every year where they ask people questions about family. And for the last 50 years or so, a question was asked, would you want your child to marry someone of the opposite race? Okay? And this is a question to detect racial tensions in our country. And thankfully, the percentage of people who would be opposed to their child marrying someone of the opposite race has been decreasing, going down, 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 down. That's a beautiful, beautiful thing. Okay? Another question that's asked is what percentage of you would be unhappy if your child married someone of the opposite political party? So if the mom's a Democrat, would you want your son marrying a Republican? Or if the mom's a Republican, would you want your son marrying a Democrat? Guess where that one's going? So while interracial marriage is becoming acceptable, inter-party marriage is becoming unacceptable. Isn't that something, Kelsey?
I just find that like super interesting because I feel like there's such a shift in political parties now that like anybody, I mean, at least a lot of the people that I talk to around my age, you ask them what political party they belong to, and a lot of the answers you get, it's like, I'm fiscally conservative but socially, fiscally conservative and socially liberal. And it's like, well, what political party is that? Because
we can talk about that later. Colin?
When I was growing up, a guy that was like my second dad, who's an attorney as well, used to always tell me there were 3 things that I had to find in a man, and 2 of them were silly, and then the 3rd one was that he had to be whether it was a, Republican. But I mean, that was one of the 3 things.
So I mean, our society has made great strides forward and backwards, I suppose, right? So on the one hand, right, we're becoming more tolerant to people of different races and religions, and that's a beautiful thing. But on the same hand, we're becoming very fractured as a country. We're becoming very balkanized, and this is not a political science course, but for the first time ever in the history of the United States, or at least the last 200 years, there's not a single Democrat Southern. There's not a single Democrat from the South in the Senate, not one. Mary Landrieu lost in Louisiana. So effectively, you have a red-blue map that's almost geographically lined up, right? Where you have huge swaths of the country that are fairly conservative and mostly Republican, and huge swaths which are very liberal and still Democrat. This is not operating in a vacuum, right? The same people who don't want their daughter marrying a Republican aren't going to vote for a Republican in Congress. And the same people who don't want their son marrying a Democrat not voting for a Democrat in Congress. So it's not surprising that the people being sent to Washington reflect this polarization, right? It shouldn't surprise you that the people being sent to Washington are not going to be those in the middle, but on the polls in both kinds. And this goes both ways, Republican, Democrat, it doesn't matter, right? The median voter, right, the moderates are gone from both parties. They don't exist. They may have existed 10, 20 years ago, but they're basically all fading out. So is it really surprising, right, when you have a Congress that's so fractured that they can't get along, right? Often the attention is like, oh man, these horrible congressmen are being unreasonable. Well, who votes for them? Who's sending them to Washington? Drive around Texas, go around the District of Texas and see who the Republican constituents are, right? Drive around San Francisco and go see who their constituents are in California, right? This is not rocket science. I think it's all too easy to blame members of Congress for being unreasonable, but they're elected for a purpose to represent their constituents. And when you have people who are at such loggerheads, this is what happens, right? This is what happens. And we read in the very, Federalist number 10, right, the problem of factions, right? Madison anticipated this 200 years ago. And he effectively said the only way to solve the problem of factions is to have a very large republic with lots of different interests checking each other. And what's happened now is now they're so fractured, they're really checking each other. So none of this, of course, is to say that the president's justified. Because, of course, the president is elected by the entire country, but he still needs to get along with the Senate, right? If the Senate doesn't give him the power to act, then he can't do it alone, right? So what does Scalias say? And he has this is the money quote, right? Gridlock, this intransigence that the government spoke of. This isn't a bug of our Constitution, right? This isn't like an error. This is a feature, a calculated feature at that. And it was designed to operate in this exact fashion. Because imagine an alternate reality where all the members of Congress agreed with each other and they sung Kumbaya, right? Wouldn't that be awesome? Legislation would speed through the Congress. Zip, zip, zip. Scalia said this is not how our Constitution was designed. Breyer makes a point that our Constitution has a purpose of efficiency. He makes this point over and over again, that we should have an efficient government that can deal with problems as they arise. Scalia's like, no. Our government is meant to raise red flags when people don't get along, especially when you have this partyism where everyone hates each other in Washington. They can't stand each other's guts. And by the way, I don't think it's getting better anytime soon. What happens? Gridlock, right? Gridlock maintains the status quo. And I want to draw a juxtaposition, if I may. So we'll be studying this, I think, in a week or two. But the Constitution says the president shall take care of the laws of faithfully executed, right? PJ, what does it mean, shall? Is there any option there, right? Okay. So we know the president has to execute the laws. He has no discretion there. We'll talk about that in a few weeks, right? PJ, does Congress have to pass any laws? No. Everyone know this cartoon? Remember how a bill becomes a law, schoolhouse rocks? Remember how hard it was, that poor Bill? Remember those other little sad Bill crying on the steps? He's like, oh, I couldn't become a Bill, right? It's hard. It's hard for a reason. And the reason why it's hard is because there are a lot of checkpoints you have to get. You have to get the House, you have to get the Senate, the President. I mean, everyone has to agree. Does Congress have any duty to pass laws? Look at that sad Bill. Look how sad he is. He's crying. He's like, dude, I'm going to be stuck here on the steps of Capitol Hill. No. No duty. Okay? So, viewed against this backdrop, right, this presidential philosophy of executive power based on gridlock, which is the theme of my paper, right, this entire idea of having executive power when Congress doesn't get along strikes me as very difficult to reconcile with the Constitution. Very difficult. And the president's basically said it in very explicit terms. We can't wait. We cannot afford to wait for Congress. I'm going to go ahead and move without them. Now, I think Congress is largely at fault for not passing laws that need to be passed for immigration otherwise. There's really not much of an excuse to leave this problem festering. But once Congress says no, that's the end of the story, right? This isn't like where, you ask your mom for something, your mom says no. You ask your dad for something, he says no, then you ask grandma, right? You only have mom and dad. You don't have a grandma. You have Congress and the Senate. Those are your options. You can't ask grandma to go around it. Or you can't, take a joyride and do it yourself. In fact, the president's actually made this "we can't wait" platform his mantra. He has a sign everywhere about "we can't wait" for Congress. And you can buy the buttons if you want. Yeah, and there's a website, We Can't Wait. Yeah.
But you have to wait for them to be delivered to your house.
Yeah,
It takes
because
like 2 or 3 weeks.
can't wait. So Scalia makes this point, I think, very forcefully. And by the way, some irony, when the president made that "we can't wait" speech, that was like 4 days after Noel Canning was decided. So I guess it didn't have the effect that Justice Scalia may have wanted it to have. So Scalia says, convenience and efficiency, they're not primary objectives or framework. So while it might be nice to have 5 members of the National Labor Relations Board, that might be really nice. And while it might be nice to have this immigration law that people would definitely benefit from, that's not the measure of our Constitution. In the absence of any agreement, when you have this partyism, people hate each other, stay put. Right? That's more or less what happens. And well, the president says, well, when they insist on obstruction, I'll keep taking actions on my own. The entire idea of obstruction is a bad thing. It's something I want to disabuse you of, right? Obstruction might be a bad thing from your political view of whether you like a policy or not. And I'm largely agnostic on policy. It's a weird thing. I really don't care. I have very little. I'm a structure guy, right? I would much rather have the checks in place. Whatever policy happens, then I'll live with it. But the mere fact is obstruction doesn't license action, right? I think this brings us back to a case like Youngstown, right? Youngstown, which we covered in the very beginning of class. You have the steel mill, right? Not enough of you are laughing. There it is. There it is. Okay. Right? This is how you tell stories with memes, right? So the exception to no words is memes. I allow memes. I chose there was a hashtag, SCOTUS memes. I invented that one. So there's a bunch of
Okay, so earlier when you were asking me about who I thought had more, either or Congress or president, or who moves or who asks. But here I'm having a little trouble understanding how, because what you said earlier, obviously his party is not going to object to what he's doing when he decides to move forward.
Mm-hmm.
But in a lot of ways, they're effectively, they're failing to comply with their own duties, and they're effectively dismantling the separation of powers, but together, willingly, right? That
Complicitly.
they have a sort of professional duty, and so as much as I'd like to blame Obama for everything, there's an implication there. We're just going to go along with it, and
yes,
we don't really care about the separation of powers either, because our agenda is, right in line with his.
Unfortunately, you're right. And this is why, again, the blame is not all on the president. I think Congress shares a lot of the blame. Okay. Why does Congress share the blame? Because they willingly cede their power. They've ceded, if you say the non-delegation doctrine, which a number of you in my class last year, we discussed this, right? Congress gave to the president the power to make laws. They established these various agencies. These agencies can make law and decide judicial disputes. Okay? Congress gave up their power. They're not getting it back. In Youngstown, right? Congress said to the president, no, we're not going to give you the power to take the steel mills. But when the president took it, Angelina, did Congress say anything about it? They were silent. Remember, Congress said nothing. Jason, what's the significance of Congress saying nothing? What's the significance of that?
Sound inferior. Signifying nothing.
Yeah.
I mean,
Is that acquiescence? We discussed this last week, but
right.
So in this sense too, you have a Congress that's willing to give up its own powers, right? Congress is willing to say, you know what? This seems like a really big deal, these steel mills, the labor crisis. We're going to look the other way. We're going to turn our heads. President, do whatever you want. And that sets a precedent. Because then the next president says, oh, look what happened with Truman. I can do the same thing. I can have all the steel mills, right? I can have them all. There it is. And you set these dangerous precedents. So turn, if you will, to the last page of the Scalia. It's a concurring opinion. It's actually a dissent. Scalia concurred in the judgment, but I want you to turn to the very last page and the very last paragraph. Page 46. And I want to read you parts of it. So Scalia says here, and this is classic Scalia. This is one of his better opinions I've read, and there are a lot of good ones. He says, the tragedy of today's decision is not just the abolition of the recess appointment power, right? It's a damage to the separation of powers, right? It's very rare that the court gets a separation of powers case. There are not many of them. You study them all. I mean, there are not a lot of them, right? And Scalia says we have to take every opportunity to resolve them. This last part is very, very powerful. Our failure to do so today will resonate well beyond the particular dispute at hand. Sad, but true. The court's embrace of this theory of executive power, this adverse possession theory of executive power, will be cited in diverse contexts, including those presently unimagined, and will have the effect of aggrandizing the presidency beyond its constitutional bounds and undermining respect for the separation of powers. Hugo, what's Nino saying here? What's Scalia's point?
That basically more that on today's issue, that it's at that time during the steel mill cases, obviously they had ulterior motives for turning away, but by doing so, it created a precedent that's carrying forward into different, decades and different presidents, and it's going to continue to happen. And whatever their reasons for not standing up and upholding their duties, whatever's going on outside of what the text gives them, and it's going to continue giving the president more leverage and more power.
Yeah, Hugo, what do you think would have happened if the Supreme Court in Youngstown went the other way? The majority of the justices said, yeah, you can take the steel mills. How do you think the next president would react to that? I think Eisenhower, Nixon, and whoever else came after that.
Continue pushing the bounds.
Keep pushing.
Yeah.
Right? You give someone an inch, they take a mile. So what Scalia is saying here is that there are circumstances unimagined, right? We don't know where this case will be cited. We don't know where this case will come into play at some point in the future. So if I had told all of you on January 20th, 2001, first day of George W. Bush's term, that his presidency will be defined by locking people up from Al-Qaeda in an island in Cuba, you have laughed at me. So what are you talking about, right? If I were to tell you one of the most important cases for the Bush administration was Korematsu, right? And whether the president could detain people indefinitely, you have laughed at me. But you know what? Korematsu was decided. You want to know what? Bush relied on it. When you have a precedent that gives some executive power, right? Even if they said, oh, this is just during World War II, this is just for the Japanese, it's a temporary situation, guess what? 70 years later, in Guantanamo Bay, the president says, oh, look what FDR did to the Japanese. I can do the same thing. We don't know how this case will be cited in the future. We have no idea. We can't, we lack the clairvoyance. Chief Justice Marshall said in McCullough that the Constitution must endure for generations. Right? We don't know what's going to happen. I'll give you another example. Bush v. Gore. Right? This was a case decided in very short time frame. If you read the decision, the Supreme Court says, oh, this decision only applies to these facts and should not be extended anywhere else. Baloney. Okay? If you're another court deciding an electional issue on a tight window, you're going to cite Bush v. Gore. It's already been done. So you can't really limit these separation of powers cases to the issue before you. And Justice Breyer's decision, which effectively gives the president the power to make these recess appointments, doesn't give credence to that. And this is a point I think Scalia is making. He says, I concur in the judgment only. This is how he drops the mic, right? This is his like sign up. It's not I respectfully concur. It's I concur. So if you ever see a decision where it says I dissent, not respectfully dissent, but I dissent, that's a serious act of judicial bench slappery, okay? Do you know the word bench slap? It's actually, David Latt invented the word. It's going to be the next edition of Black's Dictionary. A bench slap. You can use your imaginations. I actually have a word too. So do you know what's the thing that Justice Ginsburg wears around her neck, the little thing? Well, it's called a jabot. But I made up the phrase neck doily. And it's going to be the next edition of Black's Dictionary. I've peaked. That's it. This is peak, Josh, and it doesn't get better than this. But anyway, so yes, there are. Yeah, the other word which is going to be in there actually controversial is litigatrix. So it's a female litigator that's fierce, but it's a portmanteau of litigator and dominatrix. So as is bench slap, which is a combination of something else and slap. So you can use your imagination. So these words have certain weight to them. Anyway. I like neck doilies. No, it doesn't bother anyone. She looks like a teacup and it's a little doily. Anyway, so Scalia's like, listen, we don't know where this is going to be applied next. And when you weaken, so imagine if they had allowed Truman to take the steel mills, right? We don't know what would happen next. But fortunately, right, we have Justice Jackson. Justice Jackson, if you recall, had spent years prosecuting Nazis at Nuremberg. He was prosecuting the Nazis, the war crimes, and he knew firsthand what happens when the separation of powers collapses. Remember what he said? The courts are going to be the last, not the first, to give up this fight. The courts will be the last, not the first, to give up this fight. In line. His icon, Oliver Wendell Holmes, if you know anything about Oliver Wendell Holmes, Holmes says this wonderful quote. He says, if my fellow people want to go to hell, I'll help them get there. And he meant it. He meant it. We will talk about Holmes, but he meant it. And Breyer is a Holmes protege. I've called him Oliver Wendell Breyer at times. Anyway, so we have this twilight zone, and we have this lowest ebb. And remember, the president's power is at its lowest ebb when Congress says no, and the president says yes. Remember, no means no. So this is where we have the lowest ebb. So I want to next spend the remainder of the class talking about a couple big topics that I usually describe as ISIS, immigration, and Obamacare, not in that order. There have been various elements of the last, 5 years where the president has done various executive actions that have been in direct conflict with the intent of Congress. And I want to walk you through them. Now, I know you haven't read the Obamacare case. This won't be in the Obamacare case because this happened after, the court upheld it. So as I think at least one person in this room explained, under Obamacare, many policies were canceled, okay? This wasn't an accident, okay? Even though the president repeated many times, if you like your plan, you can keep your plan. The president knew in advance that millions of people would lose their health insurance, right? Why do people lose their health insurance? Because the ACA set very high standards of what your plan has to cover. You have to cover birth control and all these other things which you might not want. If your plan doesn't meet these high qualifications, it's illegal. It doesn't comply with federal law. So these plans are to be canceled. So what happens, right? After the president said this, if you like your plan, keep your plan, it was voted the lie of the year, which is a pretty bad, in Washington, it's a pretty big deal to vote a lie of the year because there are a lot of lies there. So in the fall of 2013, as maybe some of you experienced, cancellation notices went sent out. Millions of them, unclear many. And people start saying, wait a minute, you told me if I like my policy, I can keep my policy. Mind you, the law was designed to cancel policies. The ACA was designed to get people off their cheap plans and put them on these more expensive comprehensive plans to subsidize old people, sick people. That's how the law works. There's no mystery about that part. So, okay, so Chris, right? You're the president, and you see that all these people getting their policies canceled under the Affordable Care Act. What would you do? What do you think would be the one option?
Well, trying to delay or try to delay the implementation of the cancellations.
How would the president go about doing that? You're not thinking of the most obvious answer, the constitutional answer. What?
I'd say you take.
No, that's the wrong answer. What's the constitutional answer? How can the president fix the law? Veto what? It's already been signed to law. That. How can the president fix the law?
Call Congress into.
Call Congress. This is a surreal reality we live in. When I ask a class, how can the president fix the law? And the first thing that comes to mind is an executive order. This is why this messes up our society. That people think that I'm being entirely serious. Chris, I don't mean to pick on you because what you said is very typical. When I give this talk across the country, I've done it almost 40 times, okay? When I ask people, how can the president fix the law? The first answer is, oh, an executive order. No. No. Congress. Congress passed the law that bears his name, figuratively at least, and Congress can fix the law. I don't say this lightly. I mean this very sincerely. Our society has a serious problem if people don't appreciate how the separation of powers works. If people don't realize that Congress makes the laws, the president can't rewrite them, right? When the president goes on TV and says, well, when Congress does nothing, I'll take action myself. People listen to that. Young children watch that. And what scares the crap out of me is an entire generation of people grow up thinking that's the normal thing to do. I actually lie awake at night. I'm not exaggerating, worrying about this, which is why I'm a professor, so I can teach people what the hell the law is, right? This is such a dangerous thing that our republic is premised on, this ignorance. Anyway, so, yes, so that, you're right. The correct answer, the final answer, would be Congress passes a law to fix this. And Congress would be well within their power. This is a crisis. People getting by the millions their health insurance policies canceled. Like, what the hell? I don't want this. Okay, so we have a problem, right? So what does the president do instead? He uses an executive order, all right? He effectively grandfathers, oh, I'm not here yet. He effectively grandfathers all the old plans for a year. So even though all the law says on January 1st, 2014, so about a year ago and change, right? All these old plans are void. He says, you know what? Let's pretend it doesn't say that. I'm not going to penalize anyone because if you don't have insurance, you pay a penalty. By the way, about 5 million Americans this year will pay the Obamacare penalty for not having health insurance. So he says, you know what? I'm not going to charge them the penalty. Remember that individual mandate, which we said was so essential? I'm going to waive it, whatever. So the individual mandate, which was the most important thing in the world, has just been waived for a year, prospectively, for everyone. No showing of hardship needed. It's waived. Okay? There was no power to do this. He effectively modified the statute. And there's actually a lawsuit that's going on right now that was filed by the state of West Virginia challenging this, and I'll tell you more about that later. But what makes this even more remarkable, and Dat said correctly, is that the correct answer would have been go to Congress. So what do you know? The House of Representatives passes a bill to fix Obamacare. It was a one-page bill, actually about a page and a half, 2 paragraphs, right? All the bill did was they said, if your policy was valid in 2013, it's valid in 2014. That's it. That was the entire bill, nothing else. It passes with 39 Democrats, right? So Casey, if you're the president and you see that the House of Representatives passes a bill that only keeps these plans valid, right? That's all it does. What do you think you'd do if you were the president?
Should try to talk to Congress more about.
Yeah,
It's longer than a year.
you'd push it on to the Senate, right? You want the Senate to approve it, right? What do you think the president did? He threatened to veto it. The president issued a veto threat saying, if the Senate passes a law that does what I just did, I will veto it. Sorry, Obamacare gets me angry. Again, every time I do this talk, I still get it. He said, the bill which did what I already did, if the Senate votes on it, I'll veto it. Only he can change the law. This is a delirium that our children will grow up with today when they think that the president vetoes a law that does what he already did. The law would have done nothing. It was a page-and-a-half bill. It was called the Keep Your Health Insurance Act of 2013 or something like that. Yes. Give me a break to take a drink. Yeah, this is water. I promise. I didn't. There's no keg in here. This is water. I only drink water. Yes, Angelina.
So kind of, in addition to my prior question, what I don't understand is how even if they're part of his political party and they're in line with his agenda, I mean, at some point, this affects people that they know, or maybe their moral integrity comes into play and they're just like, whoa, this really kind of is getting out of control. Even though I sort of started to believe him, but now he's just taking the reins and he's abusing his authority, you know. I mean, at any point in time, you don't think that this, or do you think that they're afraid?
So while the Affordable Care Act was being debated, a reporter asked Nancy Pelosi whether she had any doubts about this law is constitutional. You know what she said? Are you kidding me? Are you kidding me? Another question was asked to Speaker Pelosi at the time about the law, and she said, quote, "You'll have to pass the bill to find out what's in it." And this is not just for Democrats. I think virtually every member of Congress, with the exception of a couple, has basically given up on any fidelity to the Constitution. It doesn't matter. Someone asked, I think it was a congressman, I can't remember his name, what justifies the Affordable Care Act? You know what he said? The Good and Welfare Clause. You know the candy Good and Plenty?
I think it was Hank Johnson.
I can't remember. He said the Good and Welfare Clause.
Same guy that was afraid.
Anyway, I can't remember, but anyway.
Johnson.
So effectively, members of Congress have given up on the Constitution. It doesn't matter. I mean, with the exception of a select few. I call it the Good and Welfare Clause. I can't type. But who was it? Oh, John. I knew it was John Conyers. Anyway, so John Conyers, a member of Congress on the Senate, the House Judiciary Committee, said the Good and Welfare Clause. Right? There is no Good and Welfare Clause. There's a General Welfare Clause that doesn't even cover this. Anyway, so Angelina, to answer your question, their oath to the Constitution doesn't matter, which is why the Supreme Court's precedent saying we don't care when you guys agree on shifting this power because you don't know what the heck you're doing and you're doing it to violate liberty, right? That's why the court is supposed to serve as a backstop. Okay, we're not done yet. More Obamacare. So here, think about this. Think of this in terms of Youngstown. Congress says we want to pass a statute to fix Obamacare. The president says, no, I'm going to do it myself and veto your law. This is like digging below the lowest ebb. This is like, subterranean excursions, okay? More. Obamacare also has an employer mandate, okay? What is this employer mandate? It says if you have a business with more than 50 employees, you're required to give health insurance to your employees, right? Put your hand up. This proved to be very unpopular because there are a lot of small businesses with 50 employees that don't have a lot of money. And a lot of businesses began reducing hours below 30 hours a week because 30 hours is considered full time. So again, this proved to be unpopular. And yet
They had 52 employees.
They dropped to 49. Yeah, it happened. So what did the president do as he was waiting for I love this New Yorker cover, I was waiting for the website to work. He delayed.
Sorry, was that a floppy disk?
Yes.
Oh.
Actually, healthcare.gov was built on a floppy disk. So anyway, so the president says, can we fix it? Everyone know Bob the Builder? Yes. Yes. Okay, Bob the Builder, right. So effectively, he delayed the employer mandate not once, but twice. So it will not kick in until 2016, basically when he's almost done. Okay? This was the core aspect of the law that was just delayed twice. This is actually subject to another lawsuit by the House of Representatives, but we'll talk about that later. I don't think that one has much standing. Anyway, so yes, now you're free from Obamacare. So the negative blunt of Obamacare was basically delayed until enough people buy it that you can't get rid of it. Right? This was not an accident. The costs of Obamacare are mostly shifted till much later. We won't see the cost 2018 or later. I mean, it's going to be a while. Everything now is fine and dandy, right? But there'll be stuff that hits in a couple of years. Yeah, I love this one. So do not open until 2016. Yes.
Does that mean we're still paying a penalty on our taxes?
The individual mandate for 2013 was waived for a lot of people. But for 2014 taxes, you will have to pay it. In other words, the individual mandate tax from last year was kaput, but for this year, you have to pay it.
But here's the good news. If you want to cheat on any other aspect of your taxes,
don't pay this one.
So many IRS agents are devoted to the new paperwork for the individual mandate that they're not,
Cheat elsewhere.
yeah.
Well, I'll give you one more tip.
My mom told me literally like just to put that I have my own insurance plan and like not.
Don't lie.
Like,
Do not
well, I
lie.
pay for my own medical care.
Don't lie in the form. Don't lie. You're going to be a lawyer. You have to go pass to the bar. Not worth it. Pay the penalty, but don't lie. So what's interesting, though, is if you don't pay the penalty, under the law, the IRS has no mechanism to take it from you. All they can do is withhold it from your tax return. So if you don't have a tax return, they can't get it from you. They cannot lien, they cannot foreclose or anything. There's no mechanism to obtain the Obamacare penalty, which I think will become a problem as it gets bigger. Okay. So any questions on Obamacare? We're going to talk about the mandate and the Medicaid expansion, but all this is what happened after the Supreme Court rule. This is on the last year. This is the subject of my next book, among other things. Okay. Yes, sir.
I might be remembering this wrong. Wasn't one of the reasons why Obama was going to veto that legislation is because they had added a part that allowed them to not only keep those plans but sell more of them?
The bill was a page and a half long. It didn't do any of that.
Okay.
Yeah, if you Google, it's called like is a House bill like keep your health insurance plan of 2013 or something like that. Or if you like your plan, I've looked up the bill. It was a page and a half long. It didn't do anything. It was really straightforward. Lauren.
I have a question. It's probably really stupid. Is there any way like they can just get rid of the Affordable Care Act?
No.
Just, no.
Next question. No, I don't mean to dismiss your comment, but effectively 1/6 of the United States economy has now been changed because of the law. You can't undo that. It's like asking to undo a hurricane. You can't like put things back in place. Right? It's not possible. We'll talk about Obamacare when we do this topic, but the time to stop this was in 2010 and 2009, and it was failed, and that was that. One more vote in the Senate, we've never had it.
What can be done? I mean, what would you?
Pray? No, I mean, pray. No, I mean, we're on a collision course. It will follow through. I mean, we're going to start experiencing both the good and bad, and there's not much. I mean, perhaps a president in 2016 can change it, but that will require getting 60 votes in the Senate because, again, the political party of the will not oppose it. So pretty much you can nibble around the edges, but it's here.
And it's going to get more and more expensive because you've delayed the individual mandate, you delayed the employer mandate, which kept people from paying the ridiculous plans. You're also going to pass fixes like getting rid of the medical device tax, which is a huge funding mechanism that kept this thing, under $3 trillion because that's very unpopular. So you're going to take away all the sticks and you're going to keep giving all the carrots, and it's going to become more and more expensive.
So, I mean, look, the fact of the matter is, and we can be honest about this, a lot of people will benefit from this law. It's undoubted. People who before could not afford insurance, people who were sick and had various conditions that did not allow them to obtain insurance, they're going to benefit a lot, right? But the rest of people will not. So there was a study done in 2009 that said what percentage of people are happy with their health insurance. The number was about 80 or 90%. It was actually pretty high depending on you count it. Most people weren't clamoring for this, right? The only way this law was sold was on the promise that it would make insurance more affordable for everyone, which was never true, right? The Affordable Care Act is a redistribution. I mean, there's no other way to describe it. It's to provide health insurance to people who are sick, old, and in poverty. That's what it does. And it does that by basically shifting the cost to everyone else. And now perhaps in the aggregate, health insurance premiums might go down as a whole, but for a lot of people who are young and healthy, they will now have to pay more. And there's no way around it because the Affordable Care Act is designed to shift the cost of people who do not have insurance before. That's how this law works. So to the extent that the law was sold in a promise of lowering health insurance costs and making it more available, that was never going to be the case. This was a way to make insurance available for poor people and sick people. That's what this law does. And if that's your primary goal, to expand coverage, how many people signed up, then it's succeeding wildly. You have millions of people joining who didn't have insurance before. If that's your goal, that's fine. But if your baseline where you start from is how are people before the law versus after, it's a very different inquiry. So far too often people say, oh, well, 8 million people, 9 million people signed up. Well, that only tells a fraction of the story for the others who were affected negatively by it. You don't see the unseen cost. We'll talk more about Obamacare when we do the mandate class. All right, let's talk about immigration. And this is something that's actually very, very much live, and it's gonna. This is gonna blow up in like the next 2 weeks. Like I think I have a reading for fully execution of the law. I don't have a reading there yet. The reason why is I'm expecting a court decision in the next 10 days or so. So this is gonna blow up real quick. So let's talk about immigration. So there was a bill proposed called the DREAM Act, and the purpose of the DREAM Act was to effectively take people who came to this country illegally as children. In other words, they didn't come here on their own volition, their parents brought them or whatever it was. They came here, they went to school, they graduated from school, or they got a GED, and now they're adults. And the idea was that, listen, we should not be treating these people as, foreigners. We should provide them a path to citizenship. And we can debate yes or no whether it's a good matter of good policy. As a matter of policy, I'm again largely agnostic. I don't really have strong views either way. But this bill was debated in Congress and voted down about 11 times. I'm not exaggerating. It was brought up almost every single time in Congress, like 2003, kept being voted down. So then in 2011, it finally came within one vote in the Senate. They got 59 votes in the Senate. It did not get 60. It didn't break the filibuster. The bill died. Okay? So in terms of, the DREAM Act, right? By the way, see if you can spot the Che Guevara sign. There's always one.
Gotta be the yellow shit. No.
Right there. Right there. There's Che. There's always one. Right? So
There might be a Jamal in there.
keep it clean, right? So basically, it got one vote shy in the Senate. Okay? This is a divisive issue, no doubt, immigration. So what happens if you're the president and it's 2011 and you got one vote short of getting the DREAM Act? What do you do, Glenn?
Well, he's probably.
No, I didn't say what he. I didn't say what he's going to. What if you're the president? If you're President Gwen, what do you do?
Go back to Senate, Congress, and compromise or figure out how we could come to a agreement.
Yeah, or you're about to have another election. Maybe wait
until
for another election. Maybe get one more vote. Run on this. Say, you know what? You Republicans are being horrible in immigration. We need to have more Democrats support this immigration. Or issue a compromise. Maybe add some border security, whatever else. There are countless number of things that could have been done after the DREAM Act failed. So what did the president do? Well, in the absence of congressional action, he'll take care of it himself. So he instituted what he called deferred action. It was actually called DACA, Deferred Action for Childhood Arrivals. It's a beautiful acronym. So effectively what this law did was it didn't give people amnesty or citizenship. If you ever hear executive amnesty, tell them they're wrong, right? There's nothing about this as amnesty. What it does do is it gives them a deferral of deportation. What does that mean? The government says, if you come and you sign up, we will not remove you. We will not remove you. One better, we will give you papers to work. You can now get a driver's license. You can apply for various government benefits. You are now lawfully present in the United States. This is only for a 2-year period that can be renewed. Okay? We'll talk a lot more about the faithful execution of the laws. But what I want to talk about here is Youngstown. Again, the president says, I will fix the immigration system on my own without Congress. And he said this many times. I can't think of a clearer case for Youngstown Zone 3. Congress votes down a law. A few months later, the president says, you know what? I'm going to try and achieve the key statutory objectives of this law by myself. You didn't vote for the DREAM Act, so I'm going to give deferred action to the dreamers. The people who came here illegally as minors. Right? This is, in my mind, one of the clearest possible cases of a Youngstown Zone 3 problem. And it repeats. This happened again. So in the summer of 2014, 6 months ago, 4 days after Noel Canning was decided, I mean, this wasn't a very long time, John Boehner, the Speaker of the House, I'll get to Libya in a minute. John Boehner, the Speaker of the House, says, you know what, Mr. President, you know we've been talking about this comprehensive immigration reform. It's not going to happen. There's not support in the Congress for it. Again, the president proposed an immigration plan, debated, short on votes. Didn't have enough votes. So could the president maybe suggest another proposal, maybe give up, quit? No, quitting's for losers, right? So what happens? On November 19th or November 19th, 2014, like 2 months ago, the president announced something called DAPA. So this was DACA, right? Deferred Action for Childhood Arrivals. Now we have DAPA, Deferred Action for Parental Accountability. So while DACA covered about 1.5 million of the Dreamers, right? These are people who came here as minors. DAPA covers parents of U.S. citizens. Parents of U.S. citizens. There are about 5 million of those. In other words, a person came here and had a child, and by dint of the 14th Amendment, the child was a citizen, right? Generally speaking, if a person comes to this country legally and has a child, and the child's a U.S. citizen, the parent has to wait 21 years before the child can petition for a green card, right? Once the child turns 21, the child can then petition for a parental green card. So rather than waiting the 21 years, the president says, you know, that's too long. We're going to simply defer the deportation for these people for 2 years. Okay? Again, I'll talk about the take care clause in a few weeks. I want to talk about that now. Again, in my mind, this is Youngstown Zone 3. Congress votes against his plan. They don't even bring it up for a vote. And then he tries to achieve the key statutory objectives. So to the extent that we look to Congress as an indication of what's lawful or not, this is really easy. Now, this case, I have to admit, is subject to a challenge by your home state of Texas, and there was actually a hearing on this in Brownsville a couple weeks ago. I wrote an amicus brief on behalf of the state of Texas, so I am not quite unbiased in this matter. And the judge in that case was kept asking the governor, it's like, you know, government lawyer, this seems a lot like Youngstown, doesn't it? So when I teach you guys Youngstown, this is not some sort of idle speculation for academics. These are live, hot issues, right, that may stop this immigration program in like the next week. The judge says he's going to rule the first week in February, so I might have this next week. I don't know. And whenever it drops, you'll know about it. But this is a live issue where Youngstown is actually the deciding case. People say ConLaw is, not practical, not realistic. This is big stuff. Because if the president's policy is enjoined, this case will go to the Supreme Court by the end of the month. I'm sorry, by the end of June. This case will be at Supreme Court probably by April by my count. Right? Be a great final exam question. All right. So any questions on immigration? We'll do faithful execution in another week or two whenever the judge decides that case. I may even move stuff around to get to it, but I think we'll do it. All right. So let's talk about foreign policy, right? So here, Youngstown is not exactly applicable because you remember what they said in Youngstown. Youngstown was effective at domestic policy, right? It was about labor issues on U.S. soil. Even though it involved a war, this wasn't about foreign power, so it was a domestic issue. So you may remember in 2011, we had some issues with Libya. Well, that was in better times, right? That's Muammar Gaddafi. He was still alive. So for some time, we had support for Gaddafi and then not support or whatever. But then there was a Libyan war. And the United States, this is actually a typo, it should be president, not the United States, because the United States didn't consent. So the president decided to launch various drone strikes and bomb the crap out of Libya. Right? And this is, if you ever see what a drone looks like, it's basically this unmanned aerial vehicle that can fly around for days and fire Hellfire missiles at people. Okay? So you might ask, wait a minute, was there a declaration of war? Of course not. Now, does there need to be a declaration of war? Not necessarily. So you might have studied in ConLaw something called the War Powers Resolution, right? The War Powers Resolution says the president, this was actually after Richard Nixon decided to invade Cambodia on his own, the president has 60 days. It's a clock. 60 days to use military forces without any permission. Right? After 60 days, he needs to go to Congress. And if he goes to Congress, he gets some more time. And if Congress approves, of his action, he can stay in indefinitely, right? You don't need an actual declaration of war, a resolution, or an authorization for use of force is sufficient. For example, after 9/11, on like September 18, 2001, Congress passed an authorization of use of force against Al-Qaeda, right? This is what allowed us to go into Iraq. And then in 2003 or 2002, Congress passed an authorization for force against Iraq, which has allowed President Bush to go after Saddam, right? So authorizations are fine. But the problem was we were in Libya for like 40 days, 45 days, 50 days, 55 days, and we're creeping up on the 60-day clock. And the problem was the president wasn't going to go to Congress. He's like, listen, we can finish this job now. Libya will be Libya will be awesome after we're doing this bombing strike. You know, it didn't turn out so well after that. But he says, well, let's just finish this ourselves. So the president went to, let me do it like this. I usually have the clicker, so I'm not my normal element. But the president went like this. So if he goes to his Defense Department, it's like, hey, DOD, buddy, old pal, so can I stay in Libya beyond 60 days? DOD says, no. Okay. So then he goes to the Justice Department. He goes to Eric Holder. Attorney General says, hey, buddy, pal, so can I stay beyond 60 days? No. All right, so let's keep track. Congress, the Senate did not want him there. The House of Representatives didn't want him to stay. Okay? The Department of Defense, the Pentagon, didn't want him to stay beyond 60 days. The Department of Justice didn't want him to stay beyond 60 days. So basically, everyone inside and outside his cabinet said, you cannot stay without more congressional power. You can't do it. So what happened? This guy. So this is a person named Harold Koh. He was a former dean of Yale Law School. And he wrote a memo. And follow me here. This memo is kind of crazy. The war resolution says, any hostilities is the key word, right? Any hostilities that last longer than 60 days need congressional support, right? Hostilities. So what did Harold Koh say? Bombing the crap out of Libya is not hostilities. I am not joking. This is what a Yale Law School dean, Yale Law School, the best law school in the world, are not hostilities. Therefore, the War Powers Resolution does not control. If any of you write that in your exam, I'll fail you. If any of you write in your exam that bombing a country is not hostilities, I will flunk you because it's ridiculous. All right? And you see the little bomb says, good morning, Tripoli. I like that one. Okay? So again, let's think about this in terms of Youngstown, right? House of Representatives said, we don't want you there. Go home. Stop bombing Libya. This is going to make a bad situation. Gaddafi's bad, but Benghazi's going to be worse, right? The Senate says, we don't want you there. The Department of Defense says, we don't want you there. Come home. Don't do this without Congress, right? Justice Department says, don't do it. But then he finds a lawyer in his White House who says, yeah, whatever, not hostilities. This is such a clear low step. But I will caveat this. I am willing to give the president the benefit of the doubt in foreign policy. I have a much more deferential approach when there's actually bombs in the ground, right? So this is not quite Youngstown because there's a foreign policy issue, but you can see that this is a very low ebb, okay? Let's talk about Bergdahl for a moment. Remember this guy? Actually, he just got about to be charged with desertion. So Bo Bergdahl was a member of the military who was captured, deserted, whatever, but he was basically held by Al-Qaeda by the Taliban for a number of years. And then a few months ago, the president has this press conference where he has Bergdahl's mother and father, and they say, we got him, we brought him back. And I'm thinking, how'd they get this guy out of the Taliban? I wonder, did the Taliban release him? What's up? So it soon as it turned out that Bergdahl, who was a deserter, which is why he was captured by the Taliban, was released in exchange for 5 high-value detainees at Guantanamo Bay. These 5 guys. So you might say, Josh, what's the problem? Why can't the president release people from Guantanamo Bay? Isn't that his commander-in-chief, his war powers? Well, it blew up. Okay, why did it blow up? Because Congress passed something called the National Defense Authorization Act. And that act said, hey, Mr. President, if you want to release anyone from Guantanamo Bay, you have to give us 30 days notice. In other words, unless you give us 30 days notice, we will not provide you any funding to release people from Guantanamo Bay. The reason why is that these people were very dangerous, right? There are a lot of people at Guantanamo who the government said they're not dangerous, we can let them go. These 5 guys were among the 7 or 8 most dangerous people there. And there was a sincere fear in Congress that these people were released, they would come back in the battlefield and kill Americans. Whether it's right or wrong, this is what Congress decided. So they put this provision into the law saying, you know what, if you want to release these guys, not anyone, but these guys in particular, you need to get 30 days notice. Because by giving 30 days notice, they can hold a hearing, make a big deal about it, object, and maybe spike the deal. Okay? This is Dianne Feinstein, who's a Democrat, who's not exactly a sort of right-winger. She said that they knew about this proposed trade, that for years, the president was considering trading Bergdahl for these 5 guys. Congress passed this law against the backdrop of Bergdahl. They knew the president wanted to release these 5 guys for Bergdahl, and they passed the law directly relating to that, saying, if these 5 guys, if you release them, give us 30 days notice. How much notice was given? None.
He was held captive for years.
Several years, yeah.
Was this the same guy that they were talking about? I don't know if any of this is artificial, if it's true, but I just heard that, and I think you used the word deserted or.
That's probably what happened.
Wandered off and.
Well, yeah, apparently he left with his compass and some water bottles, so.
But like willingly went. Like he wasn't.
It's not proven, but that's probably what happened. Right. But the Senate opposed this. Bipartisan, right? So what's interesting is initially Chuck Hagel, who was then the Secretary of Defense, said, well, the president has this power under Article 2 of the Constitution, right? He can do this by himself. And this is a very broad theory of executive power. We're actually arguing that Congress can't put strings on the executive's power, that if the president decides in national security to release these 5 guys, that's it. What makes that statement difficult is the president signed this bill into law a year earlier, right? He had a signing statement. You know, anyone know what a signing statement is? What's a signing statement, Jason? You're nodding.
It's a statement where the president signs the bill, but then has a memo to the side that says, I don't necessarily agree with the wording, or this is my interpretation of what it says. It's kind of their out clause.
So effectively, the president signed this saying, well, I'm signing this bill into law, but I don't think it's constitutional, so I won't follow it. One would think if the bill was unconstitutional, he would veto it. But instead, the president signs it and then ignores it, which I think President Bush did just the same. Again, it's very hard to think anything other but Lois Ebb here, because Congress tried to put a check on the president. He agreed to that check by signing the law. He agreed to it. He signed it. He could have vetoed it, but he signed it into law and then did exactly what Congress told him not to do. Right? There's no authorization for this. I mean, the statute. Better question is, where did he get money to do this trade? Congress said we will not fund any money for you to release these prisoners. And there's something called the Anti-Deficiency Act, which is this federal statute, you know, the ADA? Basically says a government agency can't spend money unless Congress appropriated it. So effectively, the government said you act illegally, you spent money that was not appropriated. Okay. Let's talk about ISIS, or ISIL. Or the Islamic State, yeah.
I'm sorry, I hate to go back, but why, I don't understand why he would ever, why the president would ever do a signing clause or whatever.
Signing statement, these have been going on for decades.
I mean, but like, I don't understand.
It's effectively an out, right? It says, listen, I'm gonna sign this into law, but I don't think I'm bound by it. And if it ever comes up, here's my signing statement saying I'm not bound by it.
You want funding for all of your agency, but you still want to do that one thing in there. That
Yeah, so in other words, he wanted all the money for everything else, but didn't want the strings. So this was a big deal during the Bush administration. None of you were in law school at the time. I was. And the American Bar Association made this huge study saying that signing statements were the greatest threats to civil liberties. And they were the most horrible thing in the world. And, you know, now no one cares. It doesn't matter anymore. Yeah. So let's talk about ISIS. Yeah.
Is that, so essentially are they like bartering power because he's giving up something to hopefully get something in return that he wants?
Yes, but then he backs off the deal, right? So the thing is, Congress put the National Authorization Act, the Defense Act, with these strings attached. We'll fund you if you don't do this. And the president said, okay, I'll accept this deal, and then you back out of it.
It's like a line item veto without vetoing it.
That's a very good analogy. It's a very good analogy. It's very similar to the line item veto, right? So let's talk about ISIS. So you might have heard of the Islamic State of Iraq and Syria, the Islamic State of the Iraq and Levant, or just the Islamic State, or the artist formerly known as Islamic State, whatever you want to call it, right? It's this group of really, really bad, the old Prince joke right there. It's this group of really, really bad terrorists, and they're pretty bad. I mean, these people make Al-Qaeda look moderate. In fact, Al-Qaeda expelled them. Believe it or not, Al-Qaeda said, these guys are too crazy for us. I'm not joking. Al-Qaeda actually had a meeting where they decided that they are not our people. When you're getting kicked out by Al-Qaeda, you're doing something horribly wrong. You are really, but this is relevant though. I'm not spinning jokes here. So, about 3 months ago, I was actually about to give a talk on executive powers. The night before this talk happened, I think it was in Michigan. I can't remember where it was. I think it was in Michigan. I can't remember. So the president says, you know what? You probably saw the news conference. We need to attack ISIS. They're in Iraq and Libya. Yeah, basically Iraq and Libya, right? I'm sorry, Iraq and Syria. Did he ask Congress for permission? He's like, no, I don't need permission from Congress. If they want to support me, that's fine, but I don't need permission. This is basically what Truman said. I'm going to take the seal notes. If you want to support me, yeah, that boys, but I don't need your power. Okay. So had the president justify going to war against this group which exists in Iraq and Syria? He cited originally one, but ultimately two different grounds of power. So the first one was the 2001 authorization for force against Al-Qaeda. Right? This was passed right after 9/11, where basically Congress said, all right, President Bush, go get all those people in Al-Qaeda and anyone who supports them. Okay? This was now at this point a 13-year-old resolution, which the president said he wanted to repeal. So up to about a year ago, the president said he wants to repeal the 2001 authorization, right? But now, the 2001 authorization justifies this action. What's the problem, though? The authorization was against Al-Qaeda. ISIS and Al-Qaeda are at war with each other. There's a serious problem when the group who you can target is at war with ISIS. So it's a very weak argument so that ISIS can be Al-Qaeda when they're actually at war with each other. I'm actually not exaggerating. They recently had a convention at a farmhouse, right? It's like a scene out of like the Islamic Godfather, right? So you have these two groups meeting at a farmhouse trying to like make amends with their warring families. It didn't work out, okay? So how can it be? Okay, number two, the president relied on the 2002 authorization for use of military force against Iraq, which is of course against Saddam Hussein regime. Okay, the problem with that is a very prominent constitutional law professor already declared victory in Iraq. The same as Barack Obama. We've already declared victory in Iraq. That war has been declared over. How can it be that a war that's already been declared over has been restarted against a different group that's actually in Syria? Scratch your head on that one for a moment. So neither of the bases really justifies it. Now, the president is considering now getting more authorization, but in the meantime, we've been there for 6 months bombing ISIS back to the Stone Age. Yeah.
I was just going to say that's why when everyone under the sun was calling them ISIS, White House was referring to them as ISIL, because they would refer to the Levant instead of Syria,
which is the broader region.
Which is more of the region, which brings in the region of Iraq and all that stuff. So that's why they use different terminology, and everybody's going, why in the hell are they calling them this?
They don't call them ISIL anymore. There's actually another name like Jadish. So that way you don't have to say Islamic State. They actually moved on to another phrase, which is effectively the acronym in Arabic, if I'm getting that right, which I don't think I am. Anyway, so again, I'll give the benefit of the doubt to the president on foreign policies, but this is a pretty weak case where he's effectively saying authorization against Al-Qaeda works here, even though ISIS and Al-Qaeda are at war. And where he already declared victory and pulled the troops out of Iraq, that's now justifying the other one. This is like law professor, but this is what we argue over. And it's a very weak case, okay? And it's very dangerous arguments because no one believes it. They're not plausible, right? Hostilities include bombing a country. So again, I would humbly submit lowest ebb. So this is actually, I had an article in the National Review about this. If you look closely, he's erasing the take care clause. There's my name at the bottom. Anyway, so I want to talk briefly about these costs of non-enforcement. So it's very often the case people say, well, this is Angelina's question. Well, you know what? I don't care if he's ignoring the Constitution because I like the policy, right? I like this immigration, or I like Obamacare or whatever. Well, imagine if in 2012 President Romney had won the election and he said, you know what? All of Obamacare on hold. Stop. No more implementation. Won't enforce it. Then we'll repeal it. People would not have been very happy about this, right? Or imagine if, like, President Clinton decides, you know what? I don't think it's very fair that people on welfare have to work. I don't think that. We're just going to waive the work requirement. Yep, we won't verify if you actually work. Just apply. This was actually a law her husband opposed and lost on ultimately. Or what if our own Senator Ted Cruz, right, or the darling, right? Senator Ted Cruz said, you know what? I see how President Obama said we're not going to enforce marijuana laws in certain states. You know what? Clean Air Act, Clean Water Act, Texas, have at it, boys. Frack away. I am not going to enforce any environmental laws in any state that doesn't want it. Federalism, right? People love this one. President Elizabeth Warren, right? President Elizabeth Warren says, you know what? It's unfair that all of you have student loans such high interest rates. We're going to stop collecting interest on federal student loans. No more interest. Not yay. See, you're doing exactly what I said don't do. Even if you like the results, you can't support unconstitutional actions. Don't say yay, say nay. Right? President Rand Paul, right? President Rand Paul says, well, you know what? Corporate income tax is too high, not going to collect it. If you send me a check, I'll refund it. But enforce it. We don't have enough resources to monitor all these tax offenders, so we're just going to give you all for free.
Or I'll only accept 20%. I won't take anything above.
Yeah.
Up to 35%.
Yeah.
I just won't take it.
Or President Rick Perry says, you know what? We have too many immigrants. Not giving more visas. Nope, not going to do it. Make me give out visas. Not going to happen. Right? These are serious problems. Or one example is President George W. Bush. If you were old enough to remember, he tried to reform Social Security. He lost. And you may recall after Bush lost this, he said, you know what? I'm going to do it anyway. He said, screw it, defeat. President Bush said, you know what? I'm instructing the Treasury Department, if you send me money, I will deposit into a private account for you. You could have done that individually. You didn't need any authority. Executive order. But Bush called it quits. He said, you know what? I lost. Okay? So the last case is actually House of Representatives challenge to Obamacare. And this is a really tricky case. So what happens when the president decides to disregard law in the minds of the House of Representatives? Can the House sue the president? Can the House file a lawsuit in federal court to vindicate the separation of powers?
That's what I've been wondering the whole time.
Well, you need 2/3 in the Senate to impeach. You seem frustrated by that. Anyway, so the problem is,
because that's an arm of the separation of powers, but the separation of powers is not working right now.
well, you're not going to get 2/3 to impeach anyone.
So we're just gonna keep letting him just, nah, I'm gonna do that anyways. Yeah, I'm gonna do that anyways.
Why aren't
I'm
they
gonna do
mad
that
at
anyways.
Well, one at a time. What?
Just like, why aren't they mad at him? Why don't they all want to impeach him? Like, they all hate that.
All right, Texas. Shh, Texas. Calm down, Texas. Yeah. It's funny. I had a comment on my evaluations last semester, which I still can't believe. I had two comments on my evaluations last year. So one of them said, Professor Blackman corrects us in our speech, and he said something about he's trying to impose his New England accent. and I don't know, they're anonymous. But then the comment said, this is Texas, and all of our clients are Southerners, so you should have recognized them. Okay, so I will not correct your accents. But then another comment, this was my favorite one in ConLaw. Someone said, Professor Blackman is very biased. I'm like, oh, crap. You know what? But here's the rub. He's like, we didn't even cover the Second Amendment, and this is Texas. Kid thought I was too liberal. Anyway, so I will not object to the Texas front row, short of saying that the execution row, literally, I think. From Johnstown, yes.
Yeah, I spent 15 years in Boston. So.
50, yeah, okay, and I'm from New York, so I have nothing. So, but I think the point is, right? when you have these separation of powers conflicts, right, can you shift them to the courts? And this is an issue we'll discuss. Is it desirable to have judges making decisions when you have remedies like impeachment or defunding? Angelina?
Well, back to what I just said, when the separation of powers is effectively not functioning as it should be because Congress is doing what they want, and then we have the executive doing what they want, then why not? Yeah, we need to have judiciary come in there and do a tiebreaker or figure something out.
Tiebreaker. Well, that's effectively what the House is arguing, right? So generally speaking, and I'm not teaching you standing, but to get into our federal court, you need standing. You need some sort of injury, right? So anyone, what is the House of Representatives' injury when the president doesn't enforce immigration laws? What is their injury? Anyone?
I mean, they're kind of like kindergartners. Like, he didn't listen to me. He did what he wanted. I mean,
You're not that far from the truth. But put your lawyer hat on for a minute, right? What is the injury when the president does not enforce immigration laws? Think.
Negligence, breach of contract, breach of constitution.
Zach?
Defamation.
No.
Just defames them as political.
No. Think very clearly. What is the Senate's constitutional duty? What do they do?
Into the people, so like what it affects the people that are electing, they're being elected.
And what is the president's action doing to that representation?
Yes.
Nullifying it. So there's a case called, was it Palmer v. Thompson or something v. Thompson, I can't remember the name. It was a 1930s or 40s case where effectively the Supreme Court said, right, was that if some action nullifies the vote of a legislature, that's an injury by itself. Okay? This was a very weird case. I don't want to get into the details. The case was all fractured all over the place. But if something nullifies the vote of a legislature, that's an injury to get into federal court. So effectively what the House of Representatives to show is that by the president not enforcing law, they've nullified the votes that they cast. In other words, they cast votes for this bill, this immigration law, and it's not being enforced. So the very votes they cast were basically eliminated. I am not confident this is a good argument. I'm actually very, there's not much case law on it, and I think Congress has other remedies.
The state case would probably have.
Thank you. That's why I filed a brief in the state case. I think that's actually a lot stronger, right? So what is Texas's injury from the president failing to enforce immigration laws? What's the injury that Texas suffers? And don't say don't mess with Texas. What there's actually concrete injuries. Anyone? Yeah.
Well, they were the federal government decided where to send the kids, so there's an increased welfare, there's an increased burden on the education system, there's an increased cost for the healthcare system. Because it didn't take the Medicare money, so they really hurt.
Yes, and I'll give you one very specific one. So I'm assuming everyone's room is a Texas driver's license, right? And do you remember what the fee you paid was?
Like $11.
Yeah, it's something very small, right? It might not surprise you that the cost of license is actually a lot more. To print it, the background, everything. So every single time someone gets a license, the state has to pay additional money. As a result of the president's deferred action program, the people who deferred get driver's license. And a federal court said, Arizona tried this. Arizona tried to say, we won't give any driver's license to the people on deferred action. Ninth Circuit said that was unconstitutional. So Texas is now saying, listen, if you make us give these driver's license, we're going to pay all this money for these licenses. Injury, federal court standing. I think Texas wins on standing. This is such an easy argument. You might recall there's a case called Massachusetts versus EPA, right? This was a case involving standing where Massachusetts said, follow me here. President Bush won't issue various environmental regulations. Because he won't issue the regulations, in about 3 or 4 decades, there will be global warming, the sea levels will rise, and the Massachusetts coastline will be affected. You got those chains? So because President Bush is not issuing various environmental regulations, the Massachusetts coastline will be eroded by global warming. Okay? That's a very speculative injury that may happen or may not happen. But Texas is saying, listen, it's a deep cost. So I think Texas is having a lot of things. I don't think the House should not sue over this. I really hope they don't. So it'll mess things up. Texas will get an injunction next week, but this case is going to be very important. So I don't think this case will succeed very far. Anyway. All right, so questions? No? All right, so in the remaining couple minutes, about 9 of you have come to talk about your topics. That means the rest of you haven't. My time's already scheduled to talk people's filling up. So email me like really soon with a general sense of where you want to go and some times that you're available. I'm going to have some free time on Tuesday, and Thursday my morning's already booked, so Thursday afternoon. So if you haven't already talked to me, get this done, because you need to have a topic submitted to me in a paragraph by Sunday the 8th. Okay? So email me in the next 24 hours so we schedule a time, because I want to make sure I can give you the amount of time you need to discuss it, okay? I know half of you haven't, so I keep track. All right, thank you. Great day.